Yes.
Selvelile.
Thembo mkhulu.
Uyaphileka namhlanje?
Hayi phela siyaphila kunjani kuniqudeni?
Hayi siyacenga nathi.
Nibakhulu nina bavela enyandeni. Oh, uba usikwatha akakwazi umyuta ezinto kanene.
Ndithi I wonder kawuthwana eqawukeni xa usitsho. Xa ukhankanya
Hayi, mamela
Akayazi enyandeni.
Ayazi into yoba kulapho ungozalele khona. Nofako uyayazi uba amampondo sibambisene ngawo.
Hayi. Ndiyakuva andifuna udadela enzulwini.
Phela apho kuzawulala iikumkani zombini zezizwe ezohlukileyo ithetha into yoba sibambisene ngobo bukhosi.
Hayi. Usikwatha akakuvanga Selvelile. Ucima uhla ngobukumkani basenyandeni akayazi uba yinyanda le umvelase wavela kuyo.
Oh, hey, uyayibona ke loo nto ndonqena loo nto udadela enzulwini. Awuske nditekethe.
Oh ya.
Kuthiwa umfazi wathi uthula inyanda kwavela umvelase.
Oh. Hey, isinto simnandi.
Kakhulu.
Andisihlanganisa wonke umuntu nobethi ulapha ula ngaphakathi.
Honorable members, we have both our deputy ministers on the platform and officials of the department. Manyamza, Mamkakaza, do you have any apologies for today?
Yes, Chair. Good morning, members. We've got apologies from MP Stein. She has a doctor's appointment. Apology from the minister. I did not get the reason. Thank you, Chair.
Thank you. The minister is attending other matters of government. And she did speak to me earlier to say that she will not be in attendance, but both the deputy ministers are capable of running with today's sessions. Any other apologies, Mamkakaza?
Yes, Chair.
Yes.
We also have an apology from Tatu Masipa. He has been admitted in the hospital. Utatu Tsebekulu is attending PCO Environmental Affairs. Yes, Chair. Thank you, Chair.
Thank you. Let me therefore take this opportunity, honorable members, to welcome you as the honorable members and officials of the department and the executive as led by the deputy ministers, comrades and friends. Goeie more, good morning, molweni, dumelang, and peace be with all of you. Let me take this opportunity to welcome you back to our portfolio committee meeting, as we will be getting a briefing by the department on STAB, well known as Sectional Titles Amendment Bill, as well as the Agricultural Procedure, Agricultural Produce Agents Amendment Bill. Let us also note that, honorable members, we are dealing with both of these bills at the same time, and this will be only for the first briefing. However, we will be separating them going forward as their content is totally different. We will also start the process of advertising the two bills for public inputs and ensuring that we are all able to have the two bills attended to efficiently. We also have our legal experts that have joined the platform, which is Ms. Suzanne Isaac, who is a parliamentary legal advisor for both bills. From the Office of the State Law, we have Ms. Soraya Williams for sectional titles and Mr. Sean van Breda for agricultural produce. Let me then, honorable members, as before we receive the presentation on both sectional title amendment bill, or rather known as STEB, and the agriculture produce agent bill, I would like to make 3 introductory remarks. We have, over the past 2 weeks of this session of Parliament, been reminding each other of the impact that COVID-19 has had on all of us. We continue to encourage all South Africans in our respective constituencies to diligently follow the health and safety protocols, especially since we are still experiencing the reality of COVID infections. The sad but inevitable loss of life and the untimely departure of near and dear ones, family and friends, neighbors and colleagues. Many today are still in the throngs of battling for their lives, and others are making the long road to recovery. We are a resilient nation and will pull through this crisis as we have weathered many others before. We must be reminded by President Nelson Rolihlahla Mandela's words on his release when he said that, I quote, "I knew if I didn't leave my bitterness and hatred behind, I'd still be in prison," close quote. We must, likewise, honorable members, define a new context for ourselves in this pandemic and a post-COVID world rising above our immediate challenges. This year, honorable members, marks 50 years since the introduction of the Sectional Title Act. According to an article published on the 21st of October 2020 by the Community Schemes Ombuds Service, in 1971, the Sectional Titles Act ushered in a new era in home ownership in South Africa. The Sectional Titles Act was effected on the 19th of June 1971 and promulgated on the 30th of June 1971. The Act was finally proclaimed to come into operation almost 2 years later on the 30th of March 1973. For the first time in the history of South African law, homeowners were able to purchase a section of a building, such as an apartment, with full ownership rights on that section. We have come a long way since the South African Natives Act of 1913 and the housing crisis we inherited at the dawn of democracy. By 1993, only one formal brick house for every 43 Africans was built, compared to one for every 3.5 whites. This context in 1994 was outlined in the white paper on a new housing policy and strategy for South Africa. It highlighted the conditions prevailing at the time with a particular focus on the poor. Despite 7 million RDP units built and sprawling urban developments in most of our urban centers, land hunger and security of tenure remains real and pressing issues. Today, millions of South Africans still live in informal settlements and brave the elements in precarious wood and iron structures and squalid conditions. Honorable members, our government estimates that an additional 2 to 3 million homes are required to meet the needs. We also welcome today's presentation on the Sectional Title Amendment Bill and the various provisions and exigencies it seeks to address. South Africa boasts some of the most advanced agricultural developments on the African continent, if not in the world in some respect. The President, His Excellency Ntate Cyril Matamela Ramaphosa, made reference to the huge potential for export in the agricultural sector during his SONA 2021 address. Honorable members, the growth in our export markets post the apartheid sanctions era and the opening of global markets has necessitated new measures and legislative provisions for new issues that have emerged. The Agricultural Produce Export Agents Bill provides for such new developments, and we trust that our deliberations today will be fruitful and constructive. Let me at this juncture, honorable members, invite the honorable deputy ministers to tender any opening address before we then allow the officials to present the bills. Honorable Deputy Minister Skwatsha.
Thank you very much, Honorable Chairperson. Let me start by saying, welcoming your profound opening remarks. They really leave nothing more to say than to say they are so much spot on, because they narrate the mammoth task and the road traversed and the challenges that we still do face in the road to create a non-racial, non-sexist, democratic, prosperous country. Because our presentation as a department to you on both bills are nothing else but to choose out and work together with you as South Africans in putting the building blocks of the ideal country yearned by so many died for. And so, Chairperson, really, we are here to present to you so that you can be advised as we sharpen on issues that we might have had. The road has been long and thorny. I'm quickly reminded, without wasting your time, by the fact that not long ago, a section of the Black population, which happens to be female, was by law not allowed to have a particular kind of houses. And these are the nitty-gritties that we are trying to deal with as we create this country. Our delegation from the department side is led by our Director General, Mr. Ramasodi. He will be introducing the officials that will be doing the presentation. Myself and the Deputy Minister are here. And as you have indicated, the Minister is not here today. So without further ado, I would like to give over to the acting DG to do the necessary. Thank you very much, Chairperson.
Thank you, Honorable Deputy Minister Skwatsha. Let us welcome the acting DG Ntate Ramasodi. Please proceed.
Thank you very much, Honorable Chair and honorable members. Today we'll be taking you through two bills. I would like to thank the Deputy Minister for the introductions and also Deputy Minister Dlamini on the platform. Let me just indicate the first bill that we will take would be the Sectional Titles Amendment Bill, where we will take the members through this bill that seeks to improve and enhance the application of the implementation of the Sectional Titles Act of 1986. There are currently 18 clauses that the department will apprise the August Portfolio Committee on Agriculture, Land Reform and Rural Development on. My colleague, Mayor Antoinette Reynolds, will take the Honorable Chair and honorable members through these 18 clauses, and from which, with your guidance, we will take questions, Chair. I now hand over to Mayor Antoinette Reynolds to take honorable members through the Sectional Titles Amendment Bill. Thank you.
Good morning, Honorable Chair, Honorable Deputy Minister Skwatsha, DG Ramasodi, and members of the committee. My name is Antoinette Reynolds, and I'm from the Office of the Chief Registrar of Deeds. Now, the objectives of the bill, as was stated by the DG, is to amend the Sectional Titles Act, Act 95 of 1986, for the objective of improving and enhancing the application and implementation of the Act. Now, just as an explanation, I can mention that the registration of the Sectional Titles Act deals with the registration of your opening of sectional title schemes and the registration of the transfer of units and in the scheme and registration of sectional title mortgage bonds. Now, with sectional title schemes, you think of your big offices, big shopping centers, and townhouse schemes, etc. And that is where owners own units, and all the owners together own then the common property and undivided shares according to their participation quotas. Now, clause 1 deals with the definition, clause 1 deals with the amendment of section 1 of the Act, and that contains the definitions. And the definition of an exclusive use area refers to the exclusive use by only the owner of a section, only the owner of that unit. And it can therefore be interpreted to exclude any other person than the owner from using the exclusive use area, for instance, your lessees and your usufructuaries. So the definition is now being amended to make it clear that your exclusive use area can be used by your owner as well as the occupants thereof that are recognized by law. Then the definition of a Sectional Title Schemes Management Act is incorrectly reflected in the Act as Act 8 of 2010 instead of Act 8 of 2011. And this amendment is just necessary to reflect the correct legal position. If we can please go to the second slide. Now, clause 2 deals with the amendment of section 4 of the Act. And this section deals with the approval of development schemes. And it provides for developers to have meetings with lessees in instances where buildings is to be wholly or partially let for residential purposes. where such buildings are now to be converted into sectional title schemes. So there's a need to provide for a lessee's representative to act on behalf of a lessee and to attend such meetings in instances where a lessee cannot attend the meetings, because it's at these meetings where the lessees are provided with information on the particulars of the scheme. So it is necessary for a lessee to be there, and in case now they can't be, the Act needs to be amended to provide for a lessee's representative to attend such meetings. And Section 4.3 will be amended as provided in Clause 2 of the bill. If we can please go to the next slide. Clause 4 deals with the amendment of Section 14 of the Act. Now, this section provides for the amendment and the cancellation of sectional plans on the scheme. However, it only provides for dealings with your units, your sections that are affected by incorrect sectional plans, and not for your exclusive use areas. Your exclusive use areas being your garages, your gardens, swimming pools, elevators, etc. So there's a need for the amendment of Section 14 to also make the provisions thereof applicable to exclusive use areas that may be affected by incorrect sectional plans. And Section 14.3 and 5 will be amended to provide in that regard. And then also Section 14.8 provides for the cancellation of a sectional plan upon an application by a developer for that sectional plan to be cancelled by an order of a court. And Section 14 actually must be amended to clarify the provisions to be followed where a body corporate exists and a court makes an order for cancellation of a sectional plan. So Clause 4 provides for the amendment of Section 14.8 to make the provisions of Section 49 applicable to such instances, and it will provide for the title deeds to be lodged for endorsement by a registrar of deeds, for instance, to indicate a cancellation of the plan and the closure of the sectional title scheme, whereby the land that then will fall back into the land register, and such land will then have to be registered in terms of the provisions of the Deeds Registries Act and not the Sectional Titles Act. Now, Clause 6 deals with the amendment of Clause 17 of the Act, and this section deals with the alienation and letting of the common property. And it provides for alienation of a portion of a common property, and the Act provides that if there is an exclusive use area or a section situated on that portion of the common property that is to be transferred, then that section or exclusive use area needs to be cancelled prior to the alienation of that portion of the common property. However, Section 17 currently provides for the cancellation of part of an exclusive use area, and this section needs to be amended to reflect that it's actually the whole, the complete exclusive use area that needs to be amended, and not only the portion thereof. And Clause 6 provides in this regard. Next slide, please. Clause 8 deals with the amendment of Section 21 of the Act, and this section provides for the approval of plans of subdivision and consolidation of sections by a Surveyor General. This is where you have one big section and you want to subdivide it into 2 units, or where you have 2 smaller ones and you want to consolidate it into one bigger one. You as an owner may, through a land surveyor, of course, draft sectional plan of subdivision or consolidation to be submitted to the SG for approval. However, Section 21 does not provide for a developer prior to the establishment of the body corporate to cause such plan to be drafted and submitted. So Clause 8 now aims to amend Section 21 to provide in that regard. And Clauses 9, 10, 11, and 13 deals with the amendment of Section 22 that deals with the subdivision of sections. Clause 10 deals with the Section 23 that deals with the consolidation of sections. Section 11 deals with the amendment of Section 24 that deals with the extension of a section. And Clause 13 deals with the amendment of Section 26 that provides for the extension of the scheme. Now, all these sections deals with the registration of the subdivision or the registration of the consolidation or the registration of the extension of a scheme. Now, as provided or mentioned in the previous slide, there you approach the Surveyor General to have your sectional plan of subdivision or your sectional plan of consolidation approved. And once that is done, then you deal with the registration of the plan of subdivision and the registration of the plan of consolidation. And that is where these sections also need to be amended, also to provide for the developer, just as the case as with the body corporate, to provide the developer with the opportunity to lodge such registrations to the Registrar of Deeds for registration of those plans and registrations of those subdivisions or consolidations. If we can go to the next slide, please. Also deals with the amendment of section 23 and 24, and this is to provide for the lodgement of those deeds that need to be endorsed by the Registrar of Deeds to reflect the consolidation or the subdivision or the extension of a section. But these sections omit to make provision for the lodgements of your lease agreement and your titles that contains a real rights, for instance, your usufruct and habitatio. So the sections just need to be amended to also provide for the lodgements of those particular deeds to also be endorsed by a Registrar of Deeds to reflect then the subdivision or the consolidation or the extension of a section. Next slide, please. Now, clause 12 deals with the amendment of section 25 of the Act, and this section deals with the extension of a scheme by the addition of sections and exclusive use areas. And section 22 provides for the filing in the deeds registry of a plan to scale that shows the part of the common property which will be affected by the reservation and the manner in which the buildings are to be subdivided into section and exclusive use areas. Now that plan of scale is your block plan, and it will show exactly on which part of the common property the further buildings will be built and how many stories it will be, etc. Now section 25 does not provide for the replacement documentation to be filed in a deeds office in instances where such block plan or plan to scale has been lost or destroyed. So the proposal in clause 12A provides for the lodgement of replacement plans by the body corporate in instances where plans may be lost. Clause 16 deals with the amendment of section 54 of the Act. Now, section 54 provides for the establishment of a sectional titles regulation board. And as you know, it's this board's responsibility to keep the application and the implementation of the Act under regular review and to make recommendations to the Minister with regard to amendments of the Act. And the amendment of section 54 provides for gender issues, as well as the appointment of a Registrar of Deeds as a member of the board and another conveyances. And this will bring more practical knowledge on matters pertaining to the registration of sectional title units and the opening of sectional title registers to the board. And next slide, please. Clause 18 is my last slide, and it deals with the amendment of section 60 of the Act. And section 60 deals with transitional provisions in respect of transactions that were registered in terms of the previous Sectional Titles Act. That's Act 66 of 1971. Now, in terms of this Act, your exclusive use areas, for instance, your garages, were allocated to owners in terms of the rules of the scheme. So it will, for instance, provide for the owner of Section 1 to be allocated a garage 1 or carport 1, and the owner of Section 2 will be allocated carport 2. But under the new Act, the 1986 Act, those rights, exclusive use areas, are depicted on, it's delineated on a sectional plan, and it is ceded to owners by means of the notarial deed of cession. So clause 18 provides for the amendment of section 60 to allow owners to acquire from the body corporate to cede those rights that were allocated by means of rules, to cede those rights to them by means of the registration of a notarial deed of cession, and to also delineate those rights of exclusive use on sectional plans. That's all from my side. Thank you.
Thank you. DG, are you still there? Any other input from the officials?
Thank you very much, Honorable Chair. That concludes our presentation to the Portfolio Committee on Agriculture, Land Reform and Rural Development on the Sectional Titles Amendment Bill. Thank you very much.
Thank you, honorable members. There is a presentation on STEP. We will then go into questions, and I will allow honorable members to field their questions. If you may raise your hand. Honorable Klape. I ask the Secretariat to take off the presentation so I can be able to see the honorable members. Thank you. There we go. How are you, Honorable Klape?
I'm good. How are you, Honorable Chair?
Very well, thanks. Please proceed.
Thanks so much, Chair, and let me greet my colleagues and the leadership of the department, both political and from the administration. Chair, I welcome the presentation on the Sectional Titles Amendment Bill, and taking cue from your input when we started. This is a very necessary piece of legislation, looking at the huge amount of work that as the government has still to provide housing for our people, especially our people in the townships and rural areas. This will come very handy. I'm saying this, Chair, because when there are disputes and any other thing, as women, we bear the brunt mostly. And it's such pieces of legislation that are going to protect our interests, even on these matters. And therefore, I appreciate, Chair. I have heard you, Chair, saying we're gonna publish this for public participation moving forward, both bills separately. That is answering to my question. I was looking at the steps that has been followed up to now for this Sectional Titles Amendment Bill to have been referred to the committee. It means I just wanna be sure that we now going again for public participation. We not considering public participation that was done before. That will be my first question. Chair, there's an indication that clause 1.6 to deal with the definitions of plural form in nature, for lack of better word, of spouses and whatever, but I'm looking at what clause 1.6 to amend the definition, refining the definition. Why was it necessary to refine this definition? What is the current situation? What is happening currently that necessitates redefinition of that is catered for in clause 1? My last question, Chair, is on clause 4, that seeks to amend section 14 of the Act that provides for cancellation of sectional plan by a court order. Now I'm sitting here and thinking the processes that one needs to follow for you to cancel a sectional plan. Are there no other alternatives that could be less costly? I'm talking about the cost. My worry is the cost. That do you really need to get a court order to cancel a sectional plan? Are there no other alternatives that could be accessible or even cheaper for our people if you need to do cancellation of a sectional plan? Thanks, Chair.
Secretariat, is the chair still on?
Oh,
Yes.
I'm speaking and I don't realize that I'm muted. Honorable Mbabama, I was already saying that, but I realized I wasn't audible. Please proceed.
Oh, thank you very much, Chair. I wasn't expecting you to call on me right now, but I am ready. I'd just like to know, are there problems or were there problems in implementation of this act? Because normally when you want to amend an act, there are usually problems. And if so, what were those problems? If the department could just clarify on that. And then also, Chair, through you, I think I'm also putting this out to my colleagues on the platform. Do we have to see a report on the public participation by the department? And I'm asking that because I'm not sure if the bodies listed in the memo to the bill constitute a comprehensive list of stakeholders. So I feel that maybe if we see the report of a consolidated report of public participation by the department, then we'll be able to see if all a comprehensive list of stakeholders has been consulted. Also, Chair, I would like to state that SPLUMA was enacted in 2013, and the department is only now making amendments, especially considering that contravention of land use schemes is a criminal offense. Why did the department wait for 7 years after SPLUMA was promulgated to actually make these changes? In terms of page 4 of the presentation, I am not sure. Maybe the department could explain this lessee and developer meetings. I'm not sure that I quite got that, Chair. It missed me completely. The need for lessee and developers meetings, if they could just explain that to me. And then my last question, Chair, is on the Sectional Titles Regulations Board. What would be the main purpose of this board? And why did we not have it in the past? Because the reason why I'm asking why did we not have it in the past is that in my mind, it seems that it was not necessary to have one because sectional titles have been around for quite a long time. So why now the Sectional Titles Regulation Board, and what will the main purpose of this board be? Thank you, Chair.
Thank you, Honorable Mamun Babama. The Honorable Ntate Matias.
What have I done?
Dumela Ntate. Honorable Matias. Honorable Matias, are you on the platform? You are muted and your video is off, so we don't know if you are on the platform. Ntate Matias, Honorable Kapa. Let's move on. We'll come back to the Honorable Matias. Honorable Kapa.
Thank you, Chair. Let me also join my colleagues in welcoming and appreciating the presentations on the amendment of the bill. Amendment bill. First, I have one area of clarity, just for interest's sake, whether in this process do we have any areas where we might have a situation where there's a landowner and there's a property owner and there's a lessee, and what would happen if there is that such complication? Because I remember at some stage there was that possibility in the Transkei that landowners were different from property owners, and then how will that be addressed in this process? And secondly, just also to get a clarity, do we have a possibility of any challenges in these amendments by specific groups or interested parties? Because I know for a fact that whenever we deal with these land issues, there's always someone to feel that they are being pinched somewhere and start complaining. But in this case, I just wonder if we are sure that we don't expect such possibilities of challenges because of conflicting interests in the process of amendments. I thank you, Chair.
Thank you, Honorable Tapa. The Honorable Priet.
Hi, Chairperson. Sorry, I was minimized, so I couldn't find my buttons this morning. How are you?
Very well, thank you. You may proceed.
I'm glad. Thank you, Chairperson. Maybe just one question, and I think Honorable Mbabama mentioned that in terms of the sectional title regulatory board, I would just like more clarity on that as to how does this animal look? How are we going to, how is this board going to come to stand? How are we going to establish it? How big are we looking at this board being? And are we looking at them sitting seasonally or permanently? How, just more details on that. And how will they be governed? Are we looking at bringing in extra regulations or additional amendments just to ensure that they also do their work just and fairly? And I think Honorable Klapa mentioned it in terms of what issues were there, what problems did the department have in actually doing public participation and setting up this amendment bill, and what are we looking at when we are implementing this? Are the department foreseeing any challenges in the implementation of this amendment bill, Chairperson? And that will be all from my side today. Thanks.
Thank you, Honorable Priet. Honorable Ndabezita, I think we received an apology on his behalf. Is with us. Ndabezita.
Ayekho Ndabezitha, mna ndikhona mhla.
I can qhubeka, Honorable Muntwini.
A very good morning to you, the chair, members of the committee and the department. Being in this committee, I think I'm learning a bit of Xhosa, Zulu, there and there, Chair. Chair, the issues that I would like to actually raise here is that after the amendment, which department would actually be the implementer of this sectional amendment 50? I'm asking this, Chair, because it appears as if most of the functions would then rely on the Department of Human Settlement. I am not sure how has the department actually made sure that the same presentation is presented to Human Settlement so that come the time of implementation, they don't then have to say, well, the matter only went to the Department of Agriculture. There are those that would want to litigate, take the matter to court. Has the same presentation been done to the Department of Human Settlement, because they would also be affected by the amendments that are actually to happen there. Now, I'm very new in this parliament, Chair, and I have learned that many a times when there are amendments, it means there's a problem that the amendment actually seek to address. Now, so I just wanted to know that what is it that we see on the department has identified as the problem statement, and what legislation would actually be able to cap that they have identified as a problem statement, Chair. Now, another thing, Chair, is that has the department conducted the socio-economic impact assessment? And also, if so, what were the findings of that in summary? And is the department in a position to can actually share that with us? I'm raising this, Chair, based on what was raised at some point when we're actually having an amendment on, I forgot that legislation that we're actually dealing with. But these are some of the issues that interest parties, when we had virtual public hearings, were able to actually raise this. Now, also on the public participation, Chair, I may have missed it, pardon me, because of the network that I'm having here, but I've not seen anywhere where they mentioned the public participation in the process. And lastly, Chair, just to check if can the presentation share insights about the process of public participation and submit a report. I'm really sorry, interrupted by somebody colleague. There, Chair. The last thing, Chair, is on clause 16 of the presentation, where it explained the sectional title deed, titles regulations board. Yeah. And also, what is the rationale of increasing members of the board? I think had we found out what is the problem statement, as I earlier said, we would have seen that increasing number of members from 7 to 9 would actually address that problem statement. Now, what is the rationale on increasing members to be appointed from 7 to 9, and which minister will be responsible for appointing those people? Because most of the legislation would be applicable at the site of human settlement. So you're going to see a joint ministerial appointment in terms of members to serve there. And I think those are the issues, Chair. Thank
you, Honorable Ntate Muntwedi. The Honorable Twete.
Thank you, Chair. Thank you, Chairperson. Chair, as you have said in your opening remarks, that this bill seeks to address some of the issues that were I would say they were injustice of the past. Now, Chair, I would like, in fact, let me first greet the committee members and the department of the officials of the department and the deputy ministers. Now, Chair, a quick one. I would like the department to share with us, since the department is not directly involved in the implementation of the Sectional Titles Act, is there an interdepartmental process in place that seeks to involve relevant stakeholders, Chair, to quickly finalize this long overdue ratification of injustice? Because, Chair, honestly speaking, we've been messing up hands for a long time. Now we need to rectify those things so that it addresses the injustice of the past. I don't have any other issue on this one. Then the second one, Chair, the second issue that I want to have to raise to the department is, Chair, can the department furnish us with the report of the public participation? Honorable Hlape has raised this question that there was public participation as per the presentation. Now, is there another public participation that will be conducted? Hence, I'm moving game like a chair from the premise that there was a report of a public participation that is there in the department. I seek to get that report so that this will assist the portfolio committee chair to see whether issues raised during those public participation have been integrated in the bill that is before the committee. Lastly, Chair, I would agree with Honorable Hlape on the issue of clause 4 of section 14 of the Act. Indeed, Chair, I'm really concerned. I'm really worried that is there any other alternative ways that can address that might be quicker and cheaper in terms of dealing with the cancellation or the disputes, other than the court order and all those things? Is there any other quick way? Because, Chef, we cannot engage in a long process. Our people have been waiting for long enough, for a very long time. We need to address these things quickly, but yet we need to do a thorough job without compromising the quality. Thank you, Chair.
Thank you, Honorable Chwete. Honorable Paulsen, I see you on the platform. Welcome. Mtate Paulsen. Honorable Akbare Paulsen. Honorable Mahlo. 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 Honorable members, is there any other honorable member that I may have not recognized who would like to pose a question? If there's none, honorable members, let us proceed. I will now hand over back to the DG and the officials of the department. And if the executive would like to also give input, please feel free. My questions were actually covered by Honorable Mbabama, so I'm covered on my side. Please go ahead, DG Ntate Ramasodi.
Thank you very much, Honorable Chair and honorable members. And thanks for the questions. On the platform, we also have got our legal services that will be assisting in terms of the responses to the questions. But for now, let me give to Mary Reynolds to respond to the issues. If there are any outstanding issues that she has forgotten or has not responded to, Metsepo Matlaela from our legal legislative area will also come in to assist. If there are still some more, I'll respond to some. Thank you very much.
Thank you, DG. If I can start with Member Slape's question about the publication of the bill and the public participation. The bill was published for public comment indeed. And we did receive comment from the Law Society of South Africa. We received also comment from the Banking Association and from certain conveyances. Now, in respect of the consultation processes and everything that took place, I just want to mention also that the Sectional Titles Regulation Board was also, of course, consulted, and they support the bill. And on the board, you have the Banking Association of South Africa represented, your State Agency of South Africa, SALGA is represented on the board, the National Council of the South African Council of the Architectural Profession and the South African Council of the Technical Surveyors. They were also represented on the board. And of course, then we also did consult with Department of Human Settlements due to the Sectional Title Schemes Management Act that also have an impact. So then the next question of Ms. Slape related to the definition of exclusive use area. Why was that necessary to amend to make it clear that it can be used by people other than the owner? So this was a recommendation that was referred to the board for an amendment, and it was said that in certain, for instance, in your bigger schemes, your office blocks, especially, that there has been disputes with regard to, especially I think parking is a tense issue, and there have been disputes with regard to that, and that they wanted to see an amendment to the definition to make it clear that it was not only for the owner, the registered owner of the exclusive use area and that shop, but it was actually for your tenants and your lessees that legally rented that unit or that shop, that exclusive use area was also to their availability. Then the question with regard to section 14, the cancellation of your sectional plans by court. And yes, we do agree that it is a costly exercise, but yes, there is other provisions in section 14.8 and section 14.9 does provide for the cancellation of these plans without a court order. And that's, for instance, where your the sectional title scheme is destructed or destroyed, then the owners, the body corporate, can apply to the SG and to the Registrar of Deeds for the cancellation of that plan and the cancellation of the scheme. And also where I mentioned when you alienate a portion of the common property and the land reverts back to the land register, then those plans can be cancelled. So the Act does provide in section 14.8, 14.9 and section 40 and section 17 for the cancellation of those plans without a court order. Then Member Mbata had a question to ask if there were problems, why are we amending the Act? And I can mention that the Sectional Titles Regulation Board that is already established in terms of section 54 of the Act, they sit on an annual basis. We sit once a year, the board sit, and then they look at proposals that were received for amendment of the Act. Now, this specific Act contains proposals that stem from board meetings of 2012 up to 2016. So we don't come to Parliament every year, but they do sit annually. And as I said, that they are well represented by your estate agents, your SALGA, your architecture profession. So they looked at various proposals that they have received from their members for an amendment of the Act. And those amendments will then, of course, relate to your surveying issues as well as your registration issues, because those are the matters that are actually being dealt with by this Act. It's very technical. It only provides and deals with matters of surveying and registration issues. Then there was the question about SPLUMA. Why do we wait 7 years? There is an amendment to section 7 that deals with SPLUMA. And of course, as I mentioned before, the bill does provide for proposals that were brought to the board, to the regulation board from meetings as from 2012. However, we were not always successful to go to Parliament with our bill because it was not always regarded as a priority bill. And that is why we am here now this year to actually to enact these provisions. That is very long outstanding since 2012. Then there was a question on the Sectional Titles Regulation Board. What is its main purpose? And why did we not have this board in the past? Now, we have had the board in the past. So the only amendment that we're now affecting is to provide for 2 more members to be to be added as members, or to more persons to be added as members. Now, as I stated before, the purpose of the board is to make recommendations to the minister in respect of the application and the implementation of the Act, and to, in order to streamline the provisions of the Act and to bring it under regular review. And this is stated in section 54(1) of the Act. And in section 52, 54, you'll also see it provides for the Chief Registrar of Deeds to be the chairperson of the board. It provides for the Chief Surveyor General to be a member of the board, for one conveyancer nominated by the LPC, that's your Legal Practice Council. So we now proposed an amendment to provide for another conveyancer, more knowledge on the board with regard to registration matters. The board also provides in section 54 for architect to be nominated by the relevant council, and for a member of the banks, and then also for 2 people having special knowledge on sectional title development schemes, and that is where your SALGA and your estate agency board comes into place, because we also approach them for nominations to the board. So this is a board that has been already in operation since the promulgation of the Act. Then a member Kappa, he wanted to know how do you establish or see if there's a difference between a landowner and lessees and property owners. So one will of course have to go and look at your title deed that has been registered in the deeds office, and your title deed will reflect the ownership, of course. And then if there's any long-term leases registered over your sectional title scheme, then of course those long-term leases will also be registered and endorsed against the title deed. If there's any short-term leases, those are not registered in the deeds office. So one will then, therefore, the landowner will be in position of lease agreements in that regard. But the important matter is one will have to look at the registration information in order to establish the relationship between owner and lessees and etc. Because your registration information will provide the registration details of the registered owner of a unit. Of course, it may be that an owner has deceased or divorced. Now, in those cases, the deeds must still be updated in that regard to reflect that maybe the ownership has now fallen into the estate of a deceased person or into the estate of a sequestrated person. And in that regard, your trustee of the estate or your executor of the estate will be allowed to deal with that title deed. Then there was the question with regard to challenges of interested groups. And in that regard, I can maybe just mention the well representation of the board, and so far it provides for your SALGAM people, your estate agents people, the banking council, your financial institute people, and your surveying and architect profession to also be represented on the board. And of course, the Chief Registrar of Deeds also may receive proposals from the public, which we will also then put on the agenda for discussion at such board meetings, which take place at least once. But we do also have ad hoc meetings when the need arises. Then Member Breed, she also had questions with regard to the board. Why is, how is it presented, and how big is the board, and how often do they sit? And I think I have addressed these questions. And then Ms. Breed also wanted to know if we do foresee problems with the implementation of this bill. I can just mention that once the bill is promulgated, the Chief Registrar of Deeds also issued Chief Registrar circulars in which we explain all the different amendments that has been made to the Act. And now our Chief Registrar circulars are also published and are available to interested parties, for instance, your conveyancers, notaries, etc., legal practice councils and your architects, and the public. They can all publish these chief registrar circulars, which will be issued and are always issued upon amendment of the Act or the regulations. We do issue these circulars. Then Member Montwedi, she wanted to know with which departments we consulted and if they are affected. For instance, the Department of Human Settlements, and if we've consulted with them. So yes, we definitely have consulted with the Department of Human Settlements. Now, as I've mentioned at the meeting yesterday, the Sectional Titles Act in the past did provide its regulations for dispute resolution mechanisms that there may be disputes and sectional title schemes, and the Act that provide for arbitration processes where owners of sectional title units could then resolve their disputes. Now, it was found in the past then that the arbitration processes are very lengthy and it's very costly. And then in 2010, the Sectional Title Schemes Management Act was promulgated. It came into operation in October in 2011. Act 8 of 2011, the Sectional Title Schemes Management Act, and that act deals with all the dispute resolutions, and it provides for a chief ombud, and it, for instance, then amended the Sectional Titles Act, whereas all the consumer-related matters were taken out of the Sectional Titles Act and was actually incorporated into the Sectional Title Schemes Management Act, which is Act 8 of 2011. And there's also your Chief Ombud Service Act, which is Act 9 of 2011. And those two acts are being administered by the Department of Human Settlements. Now, those two, Act 9 of 2011, the Community Service Act, provides also for a board, your Community Service Board. And that board, just like the Sectional Titles Regulation Board, that board deals with matters pertaining to dispute resolution mechanisms, whereas the Sectional Titles Regulation Board overlooks matters pertaining to registration and surveying. The other act look at dispute resolutions. Then also a member, Motlawedi, I had a question with regard to the public participation. As I said, we did publish the bill. We did receive comment, and if needed, we can definitely submit a report on the process that was followed and on the comment that was received. Then Member Twetwe had the sound was actually unclear. I couldn't hear all the questions, but it was the question was asked if the department is indeed involved in the Sectional Titles Act and how it will be administered. I want to just mention that yes, our department is very involved in the Sectional Titles Act. Our department actually is responsible for the administration of this act, and the Office of the Chief Registrar of Deeds is then also responsible for the drafting of the Sectional Titles Amendment Bill, and it's also the Office of the Chief Registrar of Deeds that is responsible for the calling of members to sit once a year at that Sectional Titles Regulation Board. So the department is involved and responsible for all those actions. And I just wanted to mention that the Act is very technical in nature, and so far it provides for registration and surveying issues only, and that the participation process has indeed taken place, as Member Twetwe also had a question with regard to the public participation process. Maybe my colleague, Ms. Shaela, can shed some further light on a report if there's, if we need to present a report with regard to the public participation that has taken place, as well as the comment that was received in that regard. I hope and I trust that I've addressed most of the questions that was asked. Thank you very much.
Chairperson, let me allow through you, Member Shaila, to add the few questions that were left, specifically around the CS and also the consultation. Thank you very much.
Thank you, and Dr. Ramasodi, they may proceed.
Thank you very much, Chair. Good morning, Chair. Good morning, DMs. Good morning, honorable members. Ms. Reynolds has answered quite a lot of the questions. The few that she has left were from Honorable Montwedi about the socio-economic impact assessment. When we approached DPME with the bill, they looked at it, and because it is of such a technical nature, and it was not necessarily introducing any new policy changes, they gave us an exemption letter, which we can provide that the department is exempted from conducting SAS for this particular bill. And then on the process of public participation for our processes, at the level of the department, we do public comments. The bill was published for public comment, and then comments were received and processed. And as Ms. Reynolds has said, if that report is required, we can furnish it. The process that we follow is that once published, we receive the comments, we consider them, and then we factor those that are relevant into the legislation, into the draft bill that we are processing. And with this one, we also then go to the Sectional Titles Regulations Board. Maybe I need to mention the board members are appointed by the Minister of Agriculture, Land Reform and Rural Development, because this is the minister that is responsible for the legislation as a whole. So the board members are appointed in the department. So I think those were the only questions that were not responded to, but it's really just, so the board is not a new thing, it's always existed. What it does is annually it receives requests for consideration on amendment of legislation. The board sits, considers those. Once those have been considered and accepted, the board then makes recommendations to the minister that we have said. We have received comments or requests for amendment from all the relevant stakeholders, which would be your SALGA, your law society, banking association, everybody that is involved around sectional title schemes. We then receive those and then minister approves. Once minister has approved the recommendations of the board, then the work commences in drafting the relevant legislation to effect those amendments. So I think that is all that was not responded to. Thank you.
Thank you very much, Chair, and honorable members. We submit.
Thank you, DG. Is there any last bite from the executive? Honorable Paul Dlamini, on this matter before we move on to the other issues for today?
Chairperson, thanks. There would be none from me for now. Thanks very much.
Thank you, Paul Dlamini. Honorable members, with that, I think we have been covered as far as the presentation and the questions that were put forward by the honorable members on STEP, that being the Sectional Titles Amendment Bill. Let us now move on to the Agricultural Produce Agents Amendment Bill and afford the department to give us a briefing on that. I will again hand over to the executive if they want to have opening remarks on this particular bill. Then we'll hand over to the officials to do the presentation. Honorable Dlamini, Honorable Squatter,
Thanks, Chairperson. I would again do the same to let you allow the DG who will introduce the one that is going to do the presentation. Thank you very much.
Thank you, Deputy Minister Ubao Dlamini. The Honorable Deputy Minister Skwatsha, any opening remarks on this particular session?
Yeah, no, thank you very much, Chair. I think the DM has already indicated that we perhaps need to immediately give over to the department because even this one is the Agricultural Produce Act is really to make sure that we include those that were excluded from exporting their produce like vegetable and fruits and addressing all kinds of gaps. I think let's get into the detail through the DG and the officials. Thank you, Chair.
Thank you, Honorable Deputy Ministers. Let us send over to the DG and the officials of the department to lead us in the presentation.
Thank you very much, Honorable Chair and honorable members. We are now going to go through a presentation that would be looking at the Agricultural Produce Agents Amendment Bill, which really seeks to look at remedying a few issues that we have realized surfacing in the industry, including just looking at the inspections, investigations, and disciplinary actions against those export and livestock agents who at some stages you would find involved in unscrupulous activities, especially when it comes to trade with people who would bring produce in front of them, where times you would have produce that stays for a week without being sold and people not getting money or getting a pittance for it. You would also look at how the very same agents would then be given the leeway to have Fidelity insurance to look at the agricultural produce. There is also a very broad issue in terms of ensuring that there's broader regulations in terms of different sections, I think broadly defined in terms of the amendment that we are bringing here. There are a few offending definitions that we would like to rectify, look at setting quite clear timeframes and work around what we need to do with the appointment of the registrar and the responsibilities of that registrar, and also look at the giving the minister the power to approve regulations. As honorable members would have seen during the hard lockdown, there were issues around livestock auctions that we had to deal with. So this bill is quite broad in terms of trying to bring a lot of changes. So we have here a team from our branch called Economic Development, Trade and Marketing, led by Medingile. But today the presentation would be taken by the person who's responsible for this and who's the director within the unit, that is Mantata, who will take us through the process that began quite some time back in 2015 and culminated in us then meeting with the portfolio committee today just to take you through these amendments that we are proposing in terms of the Agricultural Produce Agents Act. Thank you very much, Honorable Chair and honorable members. I hand over to Mr. Stan Mantata to give the presentation.
Let me take this opportunity to greet the Honorable Chairperson, members of the Portfolio Committee, and the Deputy Ministers. I'm going to talk about the Agricultural Produce Amendment Bill of 2020 as it has been said by the DG and the Deputy Minister. I'll start with a bit of a background, just to highlight where we come from and what is it that led to this development in terms of the amendments. The old bill, the Agricultural Produce Agents, was promulgated in 1992, and with that act, it gave rise to the establishment of the Agricultural Produce Agents, which is the council that is responsible for the operations and management of the agents and so on in the markets, and also the establishment of a Fidelity Fund, which is a fund that is used to cover the losses that fresh produce farmers may incur as a result of the conduct of the fresh produce agents. Basically, the objectives of the Act is to primarily regulate the occupations of the fresh produce agents, as well as the exports and livestock agents, and also to ensure that we maintain and enhance the status and the dignity of those occupations, and also the integrity of the persons that are practicing in those spaces. As I've said earlier, that this comes from the original APA Act of 1992. What we have found from the original Act of 1992 was that the APAC, which is the council, could not undertake any inspections, investigations, and disciplinary actions against export and livestock agents. So the Act only concerned itself with the conduct of the fresh produce markets. And we would know that with other agents, there were also issues, especially when it comes to unethical conduct and all that. So basically, this amendment is primarily aimed at ensuring that all those issues that we have had in terms of the inspections and investigations, as well as the disciplinary actions that were always there for fresh produce, are now put in such a place that they will also be able to deal with the exports as well as the livestock agents. And another problem that was there from the 1992 Act was that the livestock and export agents were not compelled to Fidelity Insurance to protect the producers against losses. As I've said earlier, that the current the Fidelity Fund in the current format only covers the fresh produce people who are dealing with the national fresh produce markets in the local market. So for those that are in the exports and those that are in the livestock, they don't have an insurance of some sort to can assist in an event where they suffer losses. And again, export agents in the 1992 Act were not compelled to keep the producer trust accounts like it's done with the fresh produce agents. And the Fidelity Fund is also not insured, which for us poses a huge risk, especially in an event where there's a large claim. A large claim can easily deplete the entire fund. So we came with measures that will assist us in ensuring that we deal with that risk of not having the insurance. Basically, our act, the bill, has been developed to deal with those shortcomings, because for us those were key problematic areas that needed to be addressed. So in terms of the consultations We gazetted the bill, and we had hearings between May and June in 2015 in Gauteng, Western Province, Western Cape, KwaZulu-Natal and Limpopo. These were primarily due to the huge concentration of the participants. We also developed a report based on the consultations that we have had. And from that, the bill was reviewed and the feedback sessions were held with the affected parties between November and December in 2015. And that took place in KwaZulu-Natal, Western Cape, and Gauteng. And from that process, again, 25 organizations provided us with written warnings, written comments, and also 33 participated in public hearings where they came, they made their presentations, and that was accepted. And we then had a legal opinion from all the issues that we gathered from the public gatherings. We subjected them to the office of the Chief State Law Advisor, and they also provided clarifications in terms of what we discussed with the people out there. And the bill was also reworked as a result of that legal opinion. And they also made sure that all the measures that we have proposed there were constitutionally sound, and also they were not in conflict with other pieces of legislation. Next page. So, in terms of the objectives of this bill, we would want to amend the Agricultural Produce Agents Act of 1992 to ensure that we refine certain definitions. As I've said, that we always had fresh produce agents operating separately from the livestock as well as the export agency. So we had to define some of those definitions to ensure that there's a smooth process where all these definitions are together. And then we also had to provide for certain provisions to make sure that all these provisions are applicable to all categories of agents. As I've indicated earlier, that the old act concerned itself a lot with the fresh produce agencies. So now our job was to ensure that all these provisions apply to all categories of agencies, and also to provide clarity on the appointment of and the responsibilities of the registrar of APEC, and also to ensure that we have measures at which financial statements can be audited by the Auditor General, and also to make sure that we provide for insurance for the Fidelity Fund, and also to make sure that we provide for the establishment of trust accounts for export agents, because they currently don't have that. And also to ensure that we have insurance for both exports and fresh produce agents, because in the current format, it's only the fresh produce agents that are covered. So we have to make sure that everybody is covered. And also to ensure that the minister can approve the regulations, as well as the annual business plan and the strategy of the APEC, and provide for matters connected herewith. Next page. So in terms of the actual amendments, we have looked at the various sections And we have started with section 1, where we amended to bring certain definitions and to align definitions of the export and livestock agents with that of fresh produce agents. I have indicated earlier that this was done to ensure that both exports and livestock agents also comply with certain sections that previously applied only to fresh produce agents. And then on section 3, we have amended to ensure that only holders of a Fidelity fund or those with the registration certificates can be appointed to the APEC Council. And then we have also provided further clarity on eligibilities for appointments of the council. Here we just made sure that we give more clarity in terms of the issues that may prevent one to serve in the council, and among those are issues around citizenship, that those that are not South Africans cannot serve on the council. Those that are insolvent cannot serve. Those that have court judgment against them, and those that were found not to implement the rulings of the court, and all those measures were added to ensure that we strengthen that part, that we have fit and proper people serving on the council. And on section 7, we provided amendment just to provide the terms and conditions on the appointment of committees of the council. This was to ensure that the committees are strengthened to do their job, especially in an event where they need specialist skills. As you know that the council itself has got various committees. There are those that deal with legal issues, there are those that deal with HR, and those that deal specifically with livestock agents and so on. So we just have to make sure that we get specialist skills that can assist for that purpose. And then on section 8, we provided amendments just to clarify the conditions of service in terms of the responsibilities of the registrar. This is the head of the APEC, and also to clarify his relationship with the council. So that's what we have done on that section. And then on section 10, we have provided amendments just to expand the mandate of the council to ensure that we include the coordination and that enforcement in terms of the compulsory registration and accreditation of agents. We just felt that that part needed to be beefed up a bit, and we did that. And then on section 11, we have also amended the section just to provide the minister with the authority to approve the business plan of the council, and to also ensure that the financial statements of the council are audited by the auditor general. And on section 12A, we have also inserted some measures to safeguard the Fidelity Fund against the claims by the producers. And one of the measures there was mainly to provide the need to have insurance for the fund, so that in an event where we are faced with huge claims, that can be dealt with. We can move to the next slide. And then on section 13, we have also provided some amendments there just to provide clarity in matters relating to the payments which are allowed and can be made from the Fidelity Fund. We needed to do some strengthening there just to make sure that the terms and conditions under which the fund can be used to pay those that have incurred losses are taken care of. And then on section 14, we have also provided some amendments there, just to provide for claims against the funds, so that all the claims that are done are done in such a way that there's an affidavit, and it's done in a written form, and also to indicate the amounts of settlement that can be done, and also the limitations that can be put there, because it cannot be free for all type of things. So we have also tried our level best to strengthen that part. And then on section 16, we have provided amendments there to further clarify the circumstances under which a person may be prohibited to act as an agent. There are things that have to do with dishonesty, cheating, and stealing people's money and all that, which in our view mean that once you were involved in those things, you cannot act as an agent, because the job itself deals with the administration of people's money. So we have to make sure that we've got proper people acting as agents. And we have also inserted some subsections there, just to clarify the responsibilities of the council in the issuing of or denial of certificates, while other subsections are inserted to provide for the responsibilities of agents with regard to the use and display of certificates. And we further put more subsections there, where we provide a direction in terms of the lapsing, the suspension, and withdrawal of certificates. So this is also to strengthen the powers of the council. And then on section 17, we have provided more amendments in terms of the application to the export agents. We went also further to provide more insertions on section 17A, just to ensure that those that are into the exports also take out the insurances, as we have indicated that we believe that most of the exporters are subjected to huge risks. And in an event where they suffer losses, they don't have anywhere to turn to. So insurance for us becomes important in ensuring that people or farmers in this case are covered. And then on section 19, we've also made amendments to provide further clarity on matters relating to the trust accounts, especially in relation to the trust accounts held by market authorities. We also felt that we need to strengthen that part again, to make sure that the markets, those that are under the municipal control, have trust accounts which are run in a proper way. And then we further inserted provisions on 19A, where we will compel export agents to open the producer trust accounts, which is the accounts for the farmers that they will be exporting produce on their behalf. So we have done that. And then on section 21, we have also provided amendments there for the unclaimed monies, so that in an event where the money is not claimed after 3 years, it can go to the council, and then it can be used. And then we can move to the next page. And then we have also provided amendments there on section 22, just mainly in terms of the procedure that has to be followed in the making and approval and publishing of the rules and regulation by the minister. And then we have also looked into section 23, 24, 25, 26, 29, and 30. Mainly here, the amendments were mainly to ensure that all the provisions that are currently applicable to the fresh produce agents are also applicable to the livestock agencies. And then we have also further amended on section 25 that when it comes to the disciplinary tribunal, we need to have at least one member there who has practiced as an advocate, attorney, or magistrate. And the last part on the amendments was on Schedule 1, Part C, where we have amended and substituted the definitions of fruit and vegetables. They also used the K word in the definition of vegetables, and that was deleted because it is a derogatory term. And then on section 10, in the next page, this is mainly around the current status, just to show the process that we have followed in terms of the DG's economic sector employment and infrastructure development, that the bill was presented to them in January 2018 for submittal, and that was done. And then in 2020, the ASET committee recommended that the cabinet approves the submission of the bill to the parliament, and subsequent to that, the cabinet approved that the submission of this bill be sent to parliament. That was in August 2020. That is our presentation in line with the agricultural produce amendment bill. Thanks, Chairperson.
Thank you, Dr. Ramasodi.
We submit, Chair.
Thank you, Dr. Ramasodi and officials of the department for the presentation. Honorable members, I will open it up for questions of clarity on this bill. Honorable Kape.
Thanks, Chairperson. Let me once more again welcome the presentation on Agricultural Produce Agent Amendment Bill. I think, Chair, this also is a very important piece of legislation, looking at the situation that our producers, our farmers find themselves. And I'm sitting here, Chair, and thinking for what has been the situation. If now the current existing 1992 Act has got all these clauses to be amended, be as it may be, Chair, I just wanna appreciate, I looked at the objects of the bill, and I think there has to be regulation and there has to be provision for that. And I'm thinking, Chair, my first question here would be, for the one of the objects is to provide for trust agents, for trust accounts to be opened. On the clause 19, export agents to open producer trust accounts for farmers. Why is it necessary to have a trust account other than your normal business account? Why is it necessary to have them being opened for the producers. The objective is insurance for export and fresh produce agents. Are these agents, Chair, also involved in export marketing of this fresh produce or the livestock? If they are involved in export, because I thought agents will be talking probably domestic, what will be the difference of them and our existing PPEB or perishable products export board? How do they differ? Are we having two institutions now doing the same thing, or what is going on here? I would also want to check, Chair, in terms of the regulation of the agents currently. I saw that they will be having clauses that indicates under which circumstances they can practice, what happens in case they breach these conditions. But what is it that the department is doing to make sure that these agents are not exploiting the producers in terms of commission? They're charging uniform kind of rates on commissions. There's no exploitation, there's no price fixing. How do we monitor that? How do we regulate that currently? Thanks, Chair.
Thank you, Honorable Tape. Honorable Mbabama.
Thank you, Chair. Sorry, I don't know. Okay, there we go. Thank you very much, Chair. I noticed that although the other bill that we dealt with was pretty straightforward, this is really something that we should sink our teeth into and apply our minds very much so. Because as it says, the amendments to this bill seek to protect the rights of the producers from unregulated aspects of the fresh produce agents, which is a very important objective indeed. I am quite shocked in reading about the price fixing and dishonesty that goes on in these markets. And I think we have our work cut out for us in terms of ensuring that, you know, all of this is regulated and we can actually at least lessen the dishonesty and the other practices that the agents are, some of the agents are accused of doing. You know, Chair, it's very difficult to work on a bill or an act when you actually don't know what happens on the ground. All things being equal and COVID not being here, it would have been nice for us to actually go to one of these national fresh produce markets and see what is going on and ask questions of the farmers who are there and, you know, the agents who are there ourselves, so that we can have a better understanding, you know, of the issues at hand. For instance, I would like to understand what the purpose of the Fidelity Fund was. Seeing that there is a trust fund, then why the Fidelity Fund? And these kind of questions say that, Chair, the department must bear with us, because, you know, I'm asking this from a position of ignorance about the dealings of the fresh produce market. So I would really like to know why they developed the Fidelity Fund. And also they talk about a Fidelity Fund certificate. Who are actually given this certificate, and what does it mean if an agent is given the certificate? Who actually appoints these middlemen, the agents? And what is the need for a middleman in running a fresh produce market? Now, I understand that it is a big place and all of that, but do we really need this middleman who is called an agent? what are the differences between a fresh produce agent and an export agent? Because when I was reading the original act, I found that there are certain, can I call them policies or rules, for lack of better words, that apply to fresh produce agents that do not apply to export agents. And I would just like to find out why that is, and can an agent be both, for instance? Can they be both a fresh produce agent and an export agent? And if so, then what happens to the differences in the policies that regulate them? We also have the National Agricultural Marketing Council. No, sorry. I'm getting my notes mixed up here. The National Agricultural Marketing Council. What is its role in these fresh produce markets, if any? Does it have any role in that? And then we also have the Agricultural Produce Agents Council. Now, who are members of this council? Is it the agents themselves? And if so, then how can they regulate themselves? So you see, Chair, my questions are really coming from a point of ignorance, and I need to have a bigger background so that I can understand the legislation. I'm not sure that the department will be able to do justice to my questions, but I would really implore them to try. Thank you, Chair.
Thank you, Honorable Babama. The Honorable Mema Hlati. The Honorable Mema Hlati. The Honorable Matthias. The Honorable Matthias.
I don't see him on the platform, Chair.
Thank you. The Honorable Memasho.
Honorable Chair, thank you very much. Sorry for my video. My network is not good here. And good morning to everybody. Chair, let me say that because I've been cut off since this morning when I was trying to log in, I'm having these problems. For now, Chair, thank you very much. Let me listen to others participate as they and listen as they talk. I don't have a good network on my side. Thanks.
Thank you, Honorable Mahlo. The Honorable Briet.
Thank you, Chairperson. Chairperson, maybe let me start out when we speak of Section 1, which is the definitions of the APAC board and how we will appoint the APAC board and what the criteria is to serve on the board. And it speaks of a person of unsound mind is not fit. Maybe just a background, what defines unsound mind? How will we be able to measure that? Then secondly, Chair, in terms of Section 10, we see that APAC's mandate is expanded. And I just want to know to what extent, what is the readiness of APAC to actually to deal with this expanded mandate? We've heard in previous presentations from APAC, they are quite, they are struggling. And also in terms of financial implications, what will the amendment of this bill and the expansion of APAC's mandate actually mean in terms of finances for APAC? Then, Chairperson, maybe going to, it was somewhere between Section 10 and 14 regarding the Fidelity Fund. And I have to say, I think Honorable Mbama covered it quite broadly. But the fund, do you buy into the fund? Are you members within the fund? Do you contribute towards that? How strong is this fund? Because I am just worried that with claims being handled, that we will have more claims than the fund is actually strong enough to handle. So they can maybe just say that, and then getting to section 14 where we speak of claims and sorry, let me just get to that page so I can just refresh my memory. In terms of the claims against the fund and in terms of how they will be dealt with, I understand, and it's good that claims now have to be done in writing and that you need forms of an affidavit. But I would like to find out, as we've seen it continually in terms of all of the other claims processes and ways in which you can appeal, if I can call it that. How is the department, or rather than APAC, going to be managing this? Will there be a databases? Are we already working on maybe a prototype or a pilot project of this? Because my fear is that we will receive all of these written inputs and they will get lost. There will be no proper way to deal with them, and there will be second or third or fourth submissions regarding the exact same thing. And at the end of the day, they will not be balanced. And then just maybe in terms of what the ADG said, Mr. Ramasodi, he mentioned and he made reference to the current state of disaster that we are in, and that we really experienced almost a year ago. The issues that we had in terms of livestock and livestock auctions, and that with the amendment of this bill, the minister will now be able to promulgate regulations by herself. If maybe, and I'm quite interested in that because I was quite heavily involved with the problems regarding that, and I had a number of farmers phoning. If Mr. Ramasodi can maybe just speak to that, how will this bill actually change this? How will this bill, in terms of what sections? If I had to then guess, I would say getting to sections 23 through to 30, that might be where that is. But how will this and where exactly? And I hope I'm making sense. I think I'm losing my English words today. But how will this affect this? And Chairperson, then I think just for now, I think they've done tremendous work in terms of this. I think this is a bill that is long time overdue, but I would just like to thank the department for the work they've done. And that is all from me today. Thanks.
Thank you, Akbare Priet. The Honorable Muntwedi. Honorable Muntwedi. Connection ayivumi namhlanje. The Honorable Kapa.
Thank you, Chair. Thank you, Chair. My also join in welcoming the presentation, but my clarity is one that has been touched by my two colleagues, Honorable Club and Honorable Babama, because my concern was the relation of this act, especially when it is described in introduction, in the objectives, the relation of this with the existing legislations that establish the NAMAC and PPEBP. My concern here is whether these relations are strengthening or are becoming parallel. Actually, what is this act going to be? How is it going to be relating to the existing NAMAC and the PPEBP as councils that also are directly affected with the marketing agents? I thank you, Chair.
Tembomku Enkos, the Honorable Paulson. He was on the platform earlier. Is he still with us? Honorable Paulson seems to have left the platform. Tate Matias, are you back? Honorable Montwedi? Honorable Montwedi? The Honorable Mamutwete?
Thank you, Chair. Chairperson, mine has been touched. Chair, let me emphasize on the issue, on the clarity that can the department clarify Ukuti, what does they mean? I'm really concerned, Chair, about the wording that says unsound mind. I'm reminded, Chair, of the previous council, not of Department of Agriculture, of course, but of the Medical Council. I'm raising this, Chair, precisely because, as we all know, that we are embarking on the manufacturing of cannabis. Yes, it's not a topic for today, but such alterations, they make one to be reminded of certain issues that were there as the requirements to have a license of manufacturing, distribution, and producing cannabis. We're not discussing cannabis, Chair, but I'm just making an example that one of the things that were the requirements was they seek to say you have to be in a sound mind. Now, when this word crops up again in this on this section, on this act, it reminds me of that, Chair. Precisely because indenza ndikhumbule abantu bakuthi emampondweni ukuba zezi zinto bezibavalele ngaphandle uba ngaba bangakwazi ukutrade. Now, Chair, can we get a clarity about what is the meaning of an unsound mind? Because we are here representing the people of South Africa, but in particular, we have certain constituencies where we have to address the transformation that we are talking about as a government, the transformation policies and stuff. Lastly, Chair, in this establishment of APAC, can the department give us the current staffing profile and the financial implications? Moving forward, I hear other members are questioning the capacity to deliver and stuff. Can we at least get the feel what is the current status, staffing status, and the financial implications, so that, Chair, we can be clear on certain things. Thank you.
Thank you, Honorable Twete. Honorable Montwedi seems to be having challenges. He's asking if the Secretariat can enable him on the platform.
Am I audible?
Yes, you are audible, Honorable Montwedi. Please proceed.
Thank you very much, Chair. Just a quick one, because this thing keeps on taking me in and out.
Please proceed. Honorable Montwedi, are you still with us? He has been challenged by the network today. Honorable Montwedi. Honorable members, is there any other honorable member I have not recognized who wishes to put a question?
Chair, this is Honorable Mbabama. I missed out on a very important question, Chair. I wonder if you can indulge me and allow me to ask.
Please go ahead.
Enkosi Madiba. I was reading somewhere when I was trying to get the background to this bill that we are considering here, and I read that the national fresh produce markets. In the national fresh produce markets, there's a very slow pace of transformation. And then I also read that there are 106 agents that we have at present, and out of those, only 12 are Black agents, which is 11%. And I'd just like the department to tell me, have they deliberated on this? Is there any way that amendments to this bill could make a change in that transformation? Thank you, Chair.
Thank you, Pankom. Any other honorable member who would like to pose a question I have not recognized? The Honorable Member Hlati, are you with us? Honorable Member Hlati. All right, honorable members, I will take this opportunity to sponsor 2 or 3 questions also, and then hand over to the department for responses. In the memorandum of the Agricultural Produce Agents Amendment Bill 2020, the department reports that in preparation for the publication of the bill, the former Department of Agriculture, Forestry and Fisheries consulted widely with and obtained inputs from representatives of agents, industry stakeholders, and industry organizations, among others. Honorable members, can the department indicate whether the wide consultation also included smallholder and developing farmers organizations, such as African Farmers Association of South Africa, that being AFASA, the National African Farmers Union, NAFU, and the National Emergent Red Meat Producers Organization, known as NEPRO, most of whose members previously raised challenges in accessing domestic markets, let alone export markets. This question, honorable members, arises because none of these organizations are listed in the list of stakeholders that submitted written comments and or participated in the department's public hearings, which took place only in 4 provinces, namely Gauteng, Western Cape, KwaZulu-Natal, and Limpopo. Second one, honorable members, I'd like to ascertain if the department can explain the nature of the whole consultation process, including the public hearings that were held in 2015. It should further provide reasons why public hearings were not held in the other provinces, particularly as the department seeks to extend the objectives of the bill to apply to livestock and export market agents. Lastly, but not least, honorable members, as consultation on the bill was done in 2015, which is 5 years before its introduction in Parliament, Can the department provide reasons for the delay in the tabling of the bill, and also explain whether those submissions are still applicable and relevant? Thank you. We'll now hand over to the executive, that being the deputy ministers and the officials of the department as led by the acting DG Ntate Ramasodi. Please go ahead.
GM Dlamini might want to come in.
Yeah, I was hoping that our acting DG will come in, because in particular the issue of 2015 requires serious clarity, and we must respond to these questions. But I would urge that either UDM or the DG and the team try to respond to these matters. Thank you.
Thank you very much, Honorable Chair and Honorable Members. And thank you very much for the very thought-provoking discussions on this bill. I should also indicate that I've heard right through the presentations in terms of the real need to even go beyond what we are presenting in terms of the bill, but also touching base on the interconnections between all the bills that we are having that might have an impact in terms of the bill that we are presenting here today. There's also an element around how the council relates to the bill, and also the importance in terms of bringing other budgetary or finance mechanisms in terms of dealing with the issues around the agents. But what is important here is the unison agreement that these changes that we are bringing are critical, and we need to ensure that in terms of responding to this, we respond to the issues that the honorable members had. I've taken notes in terms of the questions that were asked. Some of them would be closely related. I would like my colleague, Ntate Mantata, to have the first bite. If he has a few areas that he has not touched, I will take them. He can leave to me the interrelations in terms of the legislative mandate that we are having. Then I will also deal with other issues that he has left behind in his response. Thank you very much, Chair.
Oh, thank you very much, DG. I also have my colleague, Elvis Nakana, who will also deal with some of the questions. We will handle them together with yourself, DG. I'll start with the issue around the price forming mechanism and all that. I think what is important here is that indeed there were issues around how the prices are set in the market, as well as some of the practices that are currently taking place. And from the departmental side, we then realized that all matters related to pricing and competition and all that were things that were supposed to be dealt with by Competition Commission. At the time when we went to the Competition Commission, there were issues around pricing when it comes to produce reservation, where there were serious allegations that some agents were reserving produce for preferred buyers, and also there were late sales where they will sell after the market is closed, so that they won't be subjected to the market system. So we have taken all those matters to the Competition Commission to conduct a thorough investigation in terms of the price issues, and we are expecting them to provide us with the report. And then on the issue of Fidelity Fund, the Fidelity Fund work in such a way that the producers of fresh produce are legally bound to contribute towards that fund for every produce that they sell. There is a contribution that that must be contributed towards the Fidelity Fund. That's how the Fidelity Fund gets it's a fund from, and then from that money they also invest it in a low what do you call it low risk investment, so that it can also generate money for them. So that's how the Fidelity Fund work. So basically, this was created in such a way that the farmers who are currently into the fresh produce will be in a position to can go and claim from that fund in an event where the actions of the exports, the extra actions of the agents have in a way made them to incur some losses. So if you have lost money as a result of the your agent, then you have a right to approach APEC, lodge a complaint, and then they will do their own investigation, and then they will pay accordingly. And the other issue I think that was raised was mainly around the exports and the local market. There is a lot there that is happening. Maybe what we can also do would be maybe at a later stage to provide the committee members with the profile of the markets in terms of how they are structured and how they operate. But what one can show for now would be that currently those people that supply fresh produce markets, they pay up to 12% of the fee. The markets will be paid 5%, and then the agencies can be paid up to 7%. So it's up to the agent to negotiate with the farmer on the percentage that they are going to charge. Currently, it ranges between 5 and 7%, and then. Yeah, I think maybe let me give my colleague Elvis to come in. I'll come in a bit later. Thanks.
Thank you very much, Mr. Mantata, and greetings to everyone, Chairperson, the honorable members, as well as our executive, the deputy ministers. And thank you to the honorable members for the questions, insightful questions raised thus far. It indeed shows that these are critical issues. Now, I will try and take the questions as raised by the various honorable members. I hope I will remember the names correctly. First, starting with the questions raised by Honorable Hlape regarding what is contained in the objects of the Agricultural Produce Agents Amendment Bill. as it relates to the issue around trust accounts for export agents. Why is it necessary to open trust accounts for export agents? Currently, the practice is that the export agents only need to operate their business accounts to handle the money that actually belongs to the producers of the produce that they trade with. And let me explain that the purpose for the trust account, as it currently relates to the fresh produce agents, is twofold. So there are two things that must happen in the trust account. There should be money coming in from the sale of the produce belonging to the producers, and there should be money going out as payment to the producers for the produce that the agents have sold. Those two major things happen. But within the normal business account of an agent, any other payments can be made. So to ensure that there is that kind of added protection to the producers, especially for the produce that goes to the export markets, we need to add in this added protection in the form of a trust account for export agents for audit and other management purposes. Because as you can imagine, in most of the cases, given our situation with fruit, for example, we export over 60% of the annual output. And the value that we export really is way higher than the sales that we would make within the local markets. So the volumes as well as the value of the produce that we are talking about here that gets handled by the export agents is really quite significant. And again, the interest and the overall objective of the Act as it is currently is to protect the interests of the principals, which are the actual producers or farmers themselves. So the addition of the trust account would result in a situation where there's that kind of direct accountability in as far as the monies that gets in and the monies that gets out are concerned. The second question related to the issue around the interrelations with the PPECB, I will leave that for the Director General. But linked to that, there was a question around the insurance that needs to be taken out by export agents. Why is this necessary? It is quite necessary because, as I indicated, the value as well as the quantities of the produce that gets handled by export agents is quite significant. And all measures necessary should be put in place to ensure that the interests of the producers are at all material times safeguarded. For example, if something happens to the produce while the produce is en route for a particular market, and this is not covered within the various risk mitigation strategies that that particular agent has, then the loss rests entirely on the shoulders of the producer or the farmer. So we are bringing in this provision regarding the addition of insurance, so that at least the agent and ultimately the farmer has some recourse whenever something doesn't go according to plan, and that results in huge losses for the producers. What is the department doing to ensure that there is no exploitation of producers in as far as the issues around commissions and or other costs are concerned when the agents deal with our producers, especially our smallholder and black producers? Mr. Mantata has already touched a bit around this in terms of the collaborations that we have with the Competition Commission to address some of the issues around price fixing as well as pollution in as far as the determination of prices on the market is concerned. This is a matter that is really concerning, given that especially smallholder as well as black producers within the South African context are really a bit behind in terms of the understanding of how the markets operate, how the prices are determined on the various platforms within the markets and all that. So this is quite important. But as Mr. Manthata indicated, this is quite a forte that we are working closely with the Competition Commission to ensure that this exploitation does not disadvantage our producers in any way. And then moving on to the questions raised by Honorable Mbabama, there were issues around the regulation of the unregulated aspects of market agents, principally what is going on the market floor, and the need for maybe members of the portfolio committee to sometimes visit the markets to ensure that you have a clear and good view in terms of how things operate on the markets. Indeed, that would be quite a good thing to do. But in as far as the issues around the conduct of the agents is concerned, this is principally the reason why the Act in the first instance exists, to ensure that the regulations that govern the operations of the agents themselves, be they fresh produce export or livestock, are in such a way that it's indeed fairness and the producer gets what is fair and due to them at the end of the day. I will go with Mr. Manthata's response regarding the proposal in terms of coming up with a plan to appraise members of the committee in terms of how the markets operate, what is currently going on. And this is good because we currently have a project running to ensure that the operations of the fresh produce markets are streamlined and become efficient. There was the question around the purpose of the Fidelity Fund when there are trust accounts. As Mr. Manthata already touched on this, the Fidelity Fund exists to compensate producers for direct losses that emanate from the conduct of agents when the produce is in the control of the agents. And specifically deals with the issues around dishonest conduct as well as theft that may emanate from that. So it really exists to cover the losses that might emanate when the produce is in the hands of the producers, and the conduct that resulted in those losses can be directly traced back to the agents and or their employees. There was the question around the issue of the Fidelity Fund certificates, who gets it, who gets to issue it. The current setup in terms of the Agricultural Produce Agents Act 12 of 1992 is that there are two sets of certificates that get issued by the Agricultural Produce Agents Council, the APEC. The one is the Fidelity Fund certificate and the other is the registration certificate. The Fidelity Fund certificate gets issued to the fresh produce agents that operate on the market, while the registration certificate gets issued to either the export agents and or livestock agents. Now, the Fidelity Fund certificates gets issued to the to the fresh produce agents because these are the only category within the three categories that contributes into the Fidelity Fund. That's why the Fidelity Fund certificates gets issued to the fresh produce agents and not to the export as well as the livestock agents, because they have no Fidelity fund of their own, or they don't contribute to the existing Fidelity fund. Who gets to appoint these agents and or middlemen? The principals for the agents are the farmers. So the produce belongs to the farmer until such time that the produce gets sold. That's why the risk of profit and loss from the point that the produce leaves the farmer to the point that it gets sold always rests on the shoulders of the farmer. That's why we need to put in place regulations and legislation like this to ensure that we always safeguard the interests of the farmer. So the principal of the agent, the boss of the agent, is the farmer. So the farmer really gets to appoint the agent. That's why the APEC has, in the previous years, tried to put in mechanisms to ensure that there are service level agreements entered into between the farmers as well as the agents to ensure that the kind of service that the farmer can expect from the agents is well articulated in the SLA. The rights and obligations of the various parties are well articulated in that, so that the risk of exploitation is somehow limited and or mitigated. What are the differences between the fresh produce agents as well as the export agents? Can one agent be both? That is, be an export agent and at the same time be a fresh produce agent? And what are the implications of this? The fresh produce agents in the main operate at the fresh produce agents. There would be a few that operates outside the fresh produce agents, what is called the off-market agents. While the export agents deal with the same kind of produce, but the purpose is to sell in the export markets. That's the main difference. Now, for the sale within the local sphere, that is within the fresh produce markets, the agent concerned needs to register with the APEC Council and be issued with a Fidelity Fund certificate. While the export part of the business, such agents only needs to register and be issued with a registration certificate and not contribute to the Fidelity Fund. So the same agents, the agent can have one portion of the agency dealing with fresh produce in the local sphere and operate as a fresh produce agent, and then have another portion dealing with export agents. And as long as the agency is in compliance or complies with the regulations that governs both the export agents as well as the livestock agents. The issue around the NAMC, I will leave this to the DG. Who are the members of the APEC and who appoints them? The members of the APEC, that is the council or the board, are appointed by the Minister for Agriculture, Land Reform and Rural Development. And they are appointed from various categories. The first category is producers of fresh produce, that is fruits and vegetables. The second category is producers of livestock products. And then the third category is fresh produce agents. The fourth category is export agents. The fifth category is livestock agents. And then there's a category where the minister can appoint two people to represent him or her. And then there are also consumers that are represented, two consumers that are represented on the council and or board. And there's also one person that represents the department at all times. So there is that kind of fair balance in terms of the composition of the council and or board. It's not only the producers that gets there and in effect self-regulate. And then there was a question around from Honorable Briad around the issue around one of the ineligibilities, the ineligibility of a person who is of an unsound mind. This, in our understanding, of course, this is subject to information or correction by our legal experts. This is determined somehow in the court of law, but as I said, our legal people need to assist us on this one. And then there was the second question around the readiness of APAC for the expanded mandate, both from a human resource perspective as well as from a financial kind of perspective. If you look at the amendments suggested in terms of the proposals for amending section 10, I think, on the functions of the council, it's not really a huge expansion, but of course we have also had interactions with the registrar of the council regarding especially the human resources capabilities currently that exist within the council, and by implication the financial implications of that if you were to expand so that you fully and effectively implement even the existing mandate of the council, given that the current funding mechanism is that the agents actually contribute financially on an annual basis, and there's no other funding except the investment that the council makes from time to time, both from the council monies as well as the monies that belongs to the Fidelity Fund. So there's always that issue around funding, how much money and where can this money be found to ensure that you effectively implement the mandate of the council, even within the current existing provisions of the Act. So that's one thing that really needs further whether you want to percentage-wise increase the contributions that the agents currently pay, or you want to divert the money that gets unclaimed from the various market agencies. The current practice is that after some time it gets deposited into the Guardian's fund, divert that and no longer take it there, and then after some time let this money be part of the council for use for the operational activities from time to time. That's another one. And the other issue is to also look at put in place risk mitigating strategies to ensure that both the council and the Fidelity Fund are really not that exposed, so that the savings that you save as a result of investigations and legal issues gets really available for the operational activities of the council, to ensure that there is that effective implementation of the provisions of the Act. The Fidelity Fund, how strong is the fund? It's not that strong. Financially, it is not that strong. That's why there's a proposal in the amendment bill that seeks to provide for the Fidelity Fund to also do some kind of reinsurance, so that it also protects itself against big losses. So pass on some of the risks that currently sits with it to another insurer in the form of reinsurance, to ensure that at the end of the day, remember the ultimate objective is to protect the interests of the producers and to provide all the necessary recourses that we can under the circumstances provide so that the risk associated with losses for producers is at all material times minimized. So it's not that strong. That's why we need the Fidelity Fund to be enabled by legislation to be able to take out reinsurance. How are the claims done against the fund? How will APAC deal with the written claims going forward? As it happens, currently the council has already indeed established mechanisms in place to deal with claims. It's just that to ensure that we deal with this in a structured way, you need to put in place mechanisms like the legislative mechanisms, just to ensure that there is that clarity so that everybody understands how things must be done. And we have also proposed in the amendment bill a reduction in terms of the time limits that claims must be lodged against the fund and the time limits that the council or the Fidelity Fund needs to deal with the claims, so that there is that speedy resolutions to the claims, so that producers are not disadvantaged. Indeed, the current proposal in the form of the amendment bill seeks to also enable the minister to enact regulations so that whenever it becomes necessary, as the example was given regarding the issues around auctions, as well as some of the regulatory mechanisms that had to be put in place speedily when there was the issues around COVID, we need this to be put in place to ensure that we can respond speedily and efficiently whenever there's a need to do this. And it would not only be limited to the issues around auctions, for example. If the minister, there's a need for the minister to provide or to promulgate regulations on any other issues that relates to the objects as well as the functions of the council as is provided for in the act and the bill, the minister would be enabled to promulgate those regulations, as long as the regulations do not infringe or are not in any way conflict with any other provisions of the existing legislation. And this also relates to the issues around transformation that another honorable member raised later on in the questions. It's just that we are not that explicit in as far as the current proposal is concerned. There was the issue around, from Honorable Kapa, around the relation of this act with the MAP, Marketing of Agricultural Produce Agents Act, as well as the Perishable Products Export Control Act. Let's leave that to the DG. And then there was the concern again raised from Honorable Chwete on the wording regarding the unsound mind. I've already dealt a bit with this. And then there was the request regarding the staffing profile of the APAC and the financial implications for implementation of the amendment bill as we are proposing. This should be done without any action, I think, if members so wish. And then there was another question from Honorable Mbavama regarding the issue around slow pace of transformation in the fresh produce agent markets. This is the issue that has already been identified by the department, as rightly acknowledged by Honorable Mbavama. And the question there was, has the department considered how the bill can be used to effect transformation and change the status quo in as far as transformation is concerned? Indeed, this is a concerning matter that affects the entire agricultural industry and the entire agricultural value chain in one way or the other. And of course, as I indicated when I answered the issues around the powers of the minister to promulgate regulations, this is another area that needs to be looked at carefully to ensure that we also build in mechanisms to ensure that there are regulations that would assist in as far as transformation is concerned. Yeah, those are some of the questions that I raised. I tried to be as fast as possible. I acknowledge that there might be some that I might have missed. That's it for now from my side. Thank you very much, Honorable Chair.
Honorable Chair. Honorable Chair.
Yes.
In addition to what my colleague, Mr. Nagana, has said.
Proceed.
Yes. I think there was also a question about why did we take so long from 2015 to now. From my side, I think one of the, not necessarily the main issue, but one of the issues was that in the initial draft bill that we prepared, we wanted to structure the APEC in such a way that it will have two functions. The first one being the regulatory one, and then the second one being the developmental one, where transformation and other issues will be taken into consideration. And the issue from the Office of the State Law Advisor at the time was that once we enter that space of development, then it will render the whole bill unconstitutional in the sense that we will now be entering the local government terrain. So for us to proceed, we have to ensure that we restrict this bill to regulatory function, which is what national government is there to do. So in a way, we had to almost redo the entire bill because a majority of the things that we were proposing at the time were mainly in line making sure that we make this a developmental, we make APEC a developmental agency. So something that the legal Office of the State Law Advisor found to be a bit problematic in as far as the legislation is concerned. Thank you.
Thank you very much, Chair. We will then take the other issues that were raised regarding the relation between the National Agricultural Marketing Council, the Perishable Product Export Control Board, and also the Agricultural Produce Act and how they relate to each other. And it's critical to outline that within the department, we have got a regulatory system. That system would first seek to establish, if there's an establishment of an entity, to set up institutional mechanisms, and then secondly, guide in terms of the conduct of that institution, whatever it is, and then lately to also direct in terms of what kind of product or activity would they be responsible for. I think that's the nomenclature on how our legislation currently is being set up. In terms of the current act that is under review that brought us here, it is mainly meant to look at three critical areas as espoused in terms of the slide that we have provided. if one looks at the way that we have outlined this, we are looking at the objects of the bill, which is looking at fresh produce, export and livestock agents in terms of that particular occupation, and also looking at the work that is being done at a particular venue, being a fresh produce area. Now, this is around looking at the conduct. Now, when a product comes into the fresh produce agent, or let's say a fresh produce market in this case, there are local laws that are applicable in terms of how a product should look like or should be graded. And in this case, we are looking at the Agricultural Product Standards Act, which is an act that is applicable here. It is looking at local standards, and it is also guiding in terms of what the export standards would be. And that act refers to the quality of a product. It's only dealing with the quality, how the product should look like outside, how the internal consistencies would be. If it's a fruit, what is the degree bricks in terms of its sweetness should be before it's exported. And it also gives us a type of grading that would go with that particular product. So your fresh produce market would need to comply with the provisions of the Agricultural Product Standards Act. Now, in a case where you would like to have that product exported, then in this case, you would need an export agent who would be registered in terms of APEC to export from a particular venue. But this person should also comply with the provisions of the Agricultural Product Standards Act as it relates to exports and as it relates to the international standards as required by the importing country in this instance. And in most instances, because the activity is carried out by the Perishable Products Export Control Board, they are looking at all exports of perishable products from the country. That is the work that they are doing. So the institution that is responsible for exports is the Perishable Products Export Control Board. They are responsible for the certification. So they certify in terms of quality, in terms of the Agricultural Product Standards Act. In this case, where you have got to look broadly on how government works, then you would then go to the next level, which was asked, I think, succinctly by Honorable Hlape, Honorable Mbabama, and Honorable Kapa, regarding the National Agricultural Marketing Council. The National Agricultural Marketing Council is set up in terms of the Marketing of Agricultural Products Act, which is also called MAPA as an abbreviation. They are set up to look at 4 critical areas, just to increase our market access for all the participants that we are having. In this case, the smallholder farmers that we are focusing on. And they are also looking at promoting the efficiency of the marketing of agricultural products in general. That's the work that they are doing. Thirdly, they are looking at optimizing the exports of the agricultural sector. And lastly, they enhance the viability of the agricultural sector. So that is at the apex level. They are looking broadly at how do we do that. And some of the functions would then be delegated to them. Their biggest function, if you look at the NAMC, is to also look at the issues that we had covered the last time around when we as a country started with the dismantling of what were previously known as export agencies in the form of the export regimes that we had. For instance, if established to look at those. They look at statutory measures in terms of levies, and they see that they are correctly implemented. That's the work of the NMC. So at a very high level, you have got a nomenclature of government entities, or even some of them private, that are looking at different aspects within the area that we are looking at as the agricultural sector. But each and every one has got a responsibility. Honorable Babama raises an issue: what would the impact be? All of these acts that we are talking about are complementary. There wouldn't be overlaps in terms of the work that is being done. Where there are overlaps, we will be bringing some of those through so that we can eliminate those overlaps. But it's mainly to ensure that the whole regulatory system that we have within the department is wholesome and is able to look at the institutional mechanisms up to the regulation that relates to a product, whether consumed nationally or to be exported. Thank you very much, Chair. Oh, Chair, just a quick one. The issue that Ndate Mantata was referring to on the reference of issues to the Competitions Commission, I think it's quite important to even see that part of the areas that we are touching was as a result of the department also identifying in 2017 some of the issues that were happening at these agencies, and we referred the matter to the Competitions Commission, and there is a report from 2017 that had 14 of these agents responding to the Commission. So we are trying to also look at this conduct to ensure that the conduct is well regulated. Thank you very much, Chair and honorable members.
Thank you, Ndate Ramasodi. Honorable members, there's the responses from the department. Any other matter arising out of the responses? You want a second bite? Okay, I take it silence.
Sorry, Chair Babama.
All right, Mamum Babama.
I'm not sure which one, but I don't know whether it was the DG who had said that it would be possible to send us a presentation on the workings of the market. I would really appreciate if the Secretariat can follow that up. Thank you, Chair.
Thank you, Mamum Babama. The honorable members, any other matters?
Nothing
I take it the Secretariat will note what Mamum Babama has raised, and we can be able to follow up on that. If there's nothing else, honorable members, this brings us to the end of our meeting. I'd like to take this opportunity to thank the executive, both the Honorable Deputy Minister Ubao Skwacha, as well as the Deputy Minister Ubao Udlamini, for their attendance and their input they've made, contributions. And also would like to thank the acting DG Ndate Ramasodi for having navigated through the presentations with us. Thank all the officials of the department that have been able to take their time and do the presentations and the briefing on both the presentations. We would like to thank all our guests that took this time, who have interest on the subjects of the committee. And thank you for your attendance. Honorable members, ladies and gentlemen, we would like to thank everyone, esteemed members of the media who also attended this session, and those that are sitting at home and following us on live stream. We thank you for your attendance. This brings us to the end of our meeting, and the meeting stands adjourned. Please continue to stay safe, sanitize, wear your masks at all times, and adhere to social distancing and all protocols and regulations of level 3 that we are in of COVID-19. Have yourself a wonderful afternoon, and we will meet in plenary at 2 o'clock. Thank you. Have a wonderful day and a great week ahead. Thank you.
Thank you, Chair.
Thanks, Chair and colleagues. Have a nice day. Bye.
Bye.
Bye, colleagues.